We've gotten the question, do I need to take money or take RMDs out of my 401k or IRA to qualify for Medicaid? It's a great question. We get that one a lot. And I think the question is particularly important because for many people, other than their home, their IRA or 401k or SEP or 403b or other qualified retirement account is sometimes their most valuable asset, and they're really concerned about it. Generally speaking, Medicaid takes the position that if you have more than $2,000 of what Medicaid in Florida considers to be countable assets, then you are not eligible for Medicaid unless you come to an attorney like myself. We have some really neat legal and ethical ways of protecting our clients' assets, even if they have significantly more than that amount. However, there is a special status provided to qualified retirement accounts. And that's just not any investment account. It's got to be a qualified retirement account. These are your 401ks, your IRAs, your Roth IRAs, your 403bs, your SEPs. It's got to fall under what the IRS considers to be a qualified retirement account. And the exception to the rule says that if you take regular distributions. Now, let's break that down for a second, because some people have to take regular distributions, right? If you are of a certain age and you have a 401k, for example, the government forces you to take what's called required minimum distributions, or RMDs. However, there are other accounts like Roth IRAs that do not have required minimum distributions. However, either way, whether the IRS says you have to take distributions or whether they do not, from Medicaid's perspective, you must take regular distributions in order to have that asset not count against you when determining whether or not you are or are not eligible for Medicaid, which means, as an example, you can have a $200,000 IRA, but if it's paying out every month or regularly, the value of that $200,000 does not count against your $2,000 limit. That's really, really beneficial for many of my clients. Now, however, what you need to be aware of is there's two components to financially qualifying for Medicaid. There's the asset test. Now, again, by taking regular distributions, you are eliminating that asset from being countable. However, by solving an asset problem, you're creating an income problem, right? Because you have to make less than a certain amount in income from all sources. And Medicaid counts everything. They count your Social Security income, they count disability income, they count pension income, and they count qualified retirement plan distributions as monthly income, okay? So if it causes your monthly income to go above the income cap requirements for Medicaid, then we have to utilize something called a qualified income trust or a Miller trust, typically, okay? So when people go, why do I have to take money out of my retirement plan? It's because we have this large asset that we want to turn invisible, right? And by taking the required distributions, you're making that asset invisible as far as eligibility is concerned. Now, sometimes we don't want more income. This is particularly true for my clients who are in a nursing home, right? If you're at home, you want more income, typically. If you're in an ALF, you want more income, typically. So you'll keep that account as is. You'll take regular distributions, and you can benefit from that additional income. However, when you're in a nursing home, you're applying for a different Medicaid program. It's called Medicaid ICP, that pays for nursing home care, as opposed to the Medicaid waiver program, which pays for home care or assisted living facility care. But if you're in a nursing home setting and applying for ICP, the deal is the facility will get all of your income from all sources combined, except $130. They call that the personal needs allowance. So your Social Security, your pension, your rental income, your 401k distributions, it's all going to go to the facility. It may have to make its way through a qualified income trust first, but it's all going to eventually wind up in the facility except for that $130. So in that situation, sometimes thinking strategically, we say to ourselves, maybe we don't want that IRA sitting out there like that. Maybe we want to cash it out, even if there's a penalty, because if we cash it out, elder needs law best elder law firm in the state of Florida, has some really neat things they can do to protect that asset. So I don't have to take the income, and so I don't have to give more money to the nursing home. But that is an analysis that has to be done on a case-by-case basis. There's really no hard and fast rules to when that makes sense. It's just something that we all have to consider and keep in the back of our mind. So hope that answers the question. Retirement accounts have kind of a special status under Florida Medicaid rules. If you are interested in talking about qualifying for the Medicaid waiver program, qualifying for the Medicaid ICP program or QMB, those are the three programs that we mostly deal with, anywhere in the state of Florida, please give us a call. Call the number on your screen. You can email scheduling@elderneedslaw.com or fill out one of our web forms, or even leave a comment in our YouTube video posts, and someone will get back to you. I look forward to serving you or your family. Thank you very much.